Well, the United States is watching closely two criminal justice trials. One trial, of course, is the Kyle Rittenhouse trial that is happening over in Wisconsin. The other trial is happening down in Georgia over the killing of Ahmaud Arbery. Joining us on the line to discuss both of these cases, Misty Marris. She, of course, is a trial attorney based in New York City, specializing in the defense of clients in entertainment, sports, employment, civil rights, and sexual assault abuse cases. She's covering both trials for HLN. She also has a new podcast called The Legal Brief on a new platform called Callin. Misty, thanks so much for joining the show. I appreciate it.
Thank you, Ben.
So why don't we start with the Rittenhouse trial? Obviously, that trial will be coming to its conclusion very shortly. And it appears as though the prosecution just humiliated itself. I think everybody who's watched this trial wonders why the prosecution even brought the case in the first place. It does raise serious questions as to prosecutorial discretion. The prosecutor's own witnesses seem to be defense witnesses. The defense witnesses made a mockery of the prosecutor. The judge obviously was very upset with the prosecutor throughout the trial because the prosecutor kept trying to pull stunts. And also, I think the judge was kind of ticked that the case was brought in the first place because, again, he evidenced no actual evidence that Rittenhouse was guilty of murder rather than self-defense.
Ben, I actually went back and reviewed the probable cause affidavit, which brought the charges against Rittenhouse, and I was kind of surprised. I hadn't read it in a while, and I was shocked to find that most of the information that we're seeing play out in the trial that tend to support a self-defense argument for Kyle Rittenhouse was already in there. It's not like any of this was truly a surprise. I always try and reserve a little bit of judgment on these cases until you really see the trial unfold, because we oftentimes find new information and new evidence that's presented before the jury. But that doesn't really seem to be the case here. So there is a question mark about the prosecution bringing this case. And then to your other point, I was really shocked at some of the prosecution's, let's just say, failure to know what their witnesses were going to say on the stand. Rule number one is that you know what your witness that you put on that stand is going to testify to. And some of what came out wasn't even surprising. So I was very shocked. And then just to my final point on the prosecution, there were some stunts, Ben. And quite frankly, it seemed like the prosecution was actually trying to goad this to become a mistrial because the case was so bad and unfolding so poorly for them. They violated a rule that you learn. I mean, I think you learn it actually on Law and Order, quite frankly, if you watch that show growing up. But you definitely learn it your first day in any trial advocacy, criminal law, or constitutional law class. You cannot question the defendant's right to remain silent or question that he did remain silent or bring that in before the jury. Prosecution tried to do that. Second of all, they just violated a court order where the court had precluded certain evidence and they tried to bring it before the court without asking for permission first. All big no-nos. Judge scolded them, and rightfully so. And quite frankly, the prosecution's case was just downhill the entire time. Defense captured their witnesses and actually made them into defense witnesses.
So, Misty, one of the things that I think a lot of people were puzzled about, and I was puzzled about it too, was the decision by the defense to even put Rittenhouse on the stand. The prosecution had so thoroughly failed to make its case that you always think as an attorney that it's risky to put a defendant on the stand. You just never know what the defendant is going to say. And again, if the prosecution fails to prove its case, the burden is on the prosecution, not on the defense. Were you surprised that they decided to put Rittenhouse on the stand?
You know, I actually was, Ben, and exactly what you said. The prosecution's case had already gone so far south. As a defense attorney, it's one of the most difficult decisions that you have to make, whether or not the defendant takes the stand, and it comes with significant risk. So if the prosecution is not fulfilling their burden of proving their case beyond a reasonable doubt, many defense attorneys will say, look, it's not worth it because the prosecution's case just is not strong. We don't need this. You really only want to put your client on the stand if it's necessary. However, there is something that all of the viewers should understand. The decision to go on the stand and to testify lies with the defendant himself. So you can tell your client that they shouldn't do it. You can explain the risks versus the rewards. If they want to take the stand, it's ultimately their determination. So I think perhaps that was part of the calculus that Kyle Rittenhouse has been demonized for this entire time. And perhaps he said to his lawyers, I want to do it. And, you know, as much as it did come with those risks, I actually think it was he did a great job. And in a self-defense case, it is good for the jury to hear what was actually going on in the person's mind who is trying to use that as a justification. So I think it ended up working out for them, but it is a risky decision.
We'll get to more with Misty Marris in just 1 second. First, this holiday season, deck the halls, walls, windows, and doors with the best deals of the year on the award-winning Ring alarm. I'm sure we all know about the Ring video doorbell by now. I mean, how could you not? But did you know that Ring makes an award-winning alarm as well? Ring Alarm is a powerful, affordable home security system you can easily install yourself. So, whether you're running across town or across the country this busy season, you and your loved ones can rest easy knowing your home is protected. And it's more than just security. Ring Alarm protects your home from flood, freeze, and fire as well. Plus, it's so much cheaper than those other companies. For what they charge for 1 month, you can get an entire year of Ring Alarm with professional monitoring. Right now, for the best deals of the year on Ring Alarm, head on over to ring.com/Ben. Every time I am out of town, I make sure that I check in on my Ring Alarm so I can keep track of my house, keep track of the kids. And sometimes, just sometimes, my little kids, they're running around constantly. I lose track of one of them. I need to use that Ring app to figure out where they are. It happens more than I would want to admit, actually. So this holiday season, deck the halls, walls, doors, and windows with the best deals of the year on the award-winning Ring Alarm. Head over to ring.com/Ben. Get a great deal on a Ring Alarm security kit today. That's ring.com/Ben. We're speaking with Misty Marris, trial attorney based in New York City, and she covers all of these trials for HLN. So, Misty, let's turn to the other trial that hasn't gained nearly as much national attention as of yet. That's the Ahmaud Arbery trial. I assume that if the defendants in that trial are let off, then presumably there will be riots and all sorts of attention will be paid to the case. But this one is a more complicated case. The Rittenhouse case seemed to be pretty clear on its face. We had all sorts of video, we had witness testimony, we had physical evidence demonstrating that Rittenhouse acted in self-defense. In this particular case, there's a lack of clarity about what actually happened surrounding the death of Ahmaud Arbery. So his actual death was caught on camera. All you can see is a series of trucks, a couple of trucks that are set up across a road. Arbery tries to run between the trucks. There's apparently a confrontation between him and a guy who is holding a gun. He goes for the gun, and he is shot in the process. It seems like the entire case comes down to the question of whether these citizens were actually legally entitled to try and make a citizen's arrest against Arbery. The original accusation is that Arbery was basically just a black guy jogging in the neighborhood, and some white racists spotted a black guy jogging in the neighborhood, started trying to track him down and effectuate a citizen's arrest. But it now appears that there may be additional evidence coming out that either Arbery was engaged in some sort of crime or that people suspected he might be engaged in some sort of crime, and that's why they were chasing him down.
Yeah, Ben, the evidence that came out on Friday through testimony of a Glenn County police officer, Robert Rash, really changed the game for the defense. So you hit the nail on the head. The key to this case is the citizen's arrest statute. So it's a twofold defense. First, the McMichaels and Roddy Bryan, the three defendants, have to be justified in engaging in this citizen's arrest or attempting to perform a citizen's arrest on Ahmaud Arbery. Then the second part is a self-defense argument similar to what we've seen. Now, you can't have the benefit of self-defense if you're the initial aggressor or provoked the attack upon yourself. That's why this citizen's arrest piece is so critical in the case. Without it, it would be difficult for the McMichaels to overcome that rule, which is called the initial aggressor rule. But here, if they engaged in a lawful citizen's arrest under the Georgia statute, which was in place at the time this happened, then we turn to the argument of self-defense. But it really hinges on the citizen's arrest law, which means that there is a reasonable and probable suspicion that a felony had been committed. And then the defendants are justified in the citizen's arrest. So what happened on Friday was a game changer. And I suspect that this case will get more media attention because it is not as cut and dry as it originally seemed when we first saw that video. So evidence came out that Ahmaud Arbery had been caught on camera at this site. So it's a house under construction owned by this man, Larry English. He had been caught 5 times on camera at night prior to the day of his death. So a lot came into play through body cam footage relating to police response by this witness that was on the stand, Glenn County police officer Robert Rash. Now, on the video, you see Officer Rash, you see the McMichaels, and they're talking about what they knew. And this happened February 11th, Ben. The Ahmaud Arbery died February 23rd. So this is insight into what they knew at the time, which is the critical piece to establish a defense under this the citizen's arrest statute. They knew that he had been there 5 times. They had heard that something had been stolen from the property. They were told that by Officer Rash that if Ahmaud Arbery was in this house. They didn't know who it was at the time, but the individual, they confirmed it was the same person that they'd seen before, that it would be trespassing, loitering, or maybe something more, leaving that door open to establish a possible felony. There had been items missing from the house. Nobody knew who took them at the time. And in addition to that, body cam footage shows Officer Rash going into the house, guns drawn, flashlight on, showing a pretty severe situation to find this person who ended up being Ahmaud Arbery seen on tape at this location. Now, the suspicion was suspicion of a burglary, which is entering a dwelling with the intent to commit a crime. So this is insight into what the McMichaels were thinking at the time. They were even told by Officer Rash, if you see this guy, here's Larry English's number. You let the McMichaels know. So there's a little bit more to the story. At the end of the day, what it appears, based on this testimony and body cam video, the McMichaels knew that Ahmaud Arbery had been seen at night in this structure, items had been missing, and Travis McMichael says in the body cam footage that he believes he'd seen Arbury before and that he believed that he was armed. So suddenly there's a new narrative here, and there is information to support the McMichael side of the case where they say they chased Ahmaud Arbery because they believed that he may have committed a crime, that they had seen him before, and that they believed him to be armed, which is why they picked up guns before they got on the road. Now, whether or not this satisfies the jury, only time will tell. There's more evidence to come, but it was certainly a game-changing day for the defense, where suddenly there are facts and information and testimony and body cam video to support the McMichaels side of the case to get to that citizen's arrest law. Now, Ben, one more point, and it's really important, and I don't think anybody's really talking about it. In order to use this citizen's arrest law, the defense has to show that they were justified by a preponderance of the evidence. Now, why does that matter? That means that it's 51-49, right? So it's a different standard of proof than beyond a reasonable doubt. So, and it's a lower standard of proof for them to use this as a defense. So if they're able to establish a defense under the citizen's arrest law and justify their chasing Ahmaud Arbery in the truck and all of that, then the self-defense argument is a bit more clear-cut because we see it on the video. So that's the hurdle to overcome. And there's certainly evidence to support the defense side of the case that is new. And this is the reason why we wait for the facts to come out, Ben, because there are two sides to this. And there's a decent case for the defense now, and we'll continue to watch the trial unfold.
So, Misty, obviously a lot of the media coverage at the time focused in on the actual shooting, which was pretty hard to watch, obviously. It also focused in, obviously, on the race of the victim or alleged victim and the race of the defendant. In this particular case, there was also some kind of loose talk about the kind of language that these guys had used. Has there been anything admitted into testimony or evidence at this point demonstrating that they were using racial slurs about Arbury, either surrounding his attempted arrest, supposedly, or around his death?
So there have not been racial slurs. They called him a joker. They said he was trapped by a rat. That did all come into evidence, and that was captured on body cam footage. What we do know is going to happen. There was some pre-trial motion practice with respect to evidence. And one item that is admitted is that the McMichaels on the back of their car have a prior Georgia flag, and it's a Confederate flag sticker on the back of their truck. So that was ultimately admitted into evidence. Presumably, when we talk about this citizen's arrest statute, they're engaging in this chase with Ahmaud Arbery, and they're asking him to stop. And I'm assuming it's going to come in that way. And that was part of the argument that, why would he stop under these particular circumstances? They're not law enforcement, so he did not have any obligation to do so. So that is going to come in. But keep in mind, they're not charged with a hate crime in this particular case. There is a federal indictment for civil rights violations that's coming down the pike, but that is not a factor in this particular case. This is all about whether or not there's a justified citizen's arrest in self-defense, or was it false imprisonment, assault, felony murder, and that's what the linchpin is in this case.
So, Misty, this could look very much like sort of the situation with George Zimmerman, where you have George Zimmerman and Trayvon Martin, and Zimmerman, according to the witness testimony and his own testimony, Zimmerman thinks that there's possibly a crime going on. He trails Trayvon Martin. Trayvon Martin just sees a guy trailing him, confronts him. They get in a fight. he's beating up Zimmerman and Zimmerman shoots and kills him. So that could theoretically be a self-defense, situation in which both sides are sort of misconstruing what's going on. It sounds like that could be this as well. If Arbury was not in fact committing a crime, it could have been exactly the same sort of situation, that they had preponderance of the evidence to believe that he was committing a crime. They started tracking him down. All he sees is a bunch of white guys following him in trucks or trying to cut him off in trucks with a Confederate flag. He tries to escape and he gets shot in the process. And that's still possibly a self-defense case, is what you're saying.
Exactly. It is still a self-defense case. And it's very similar to George Zimmerman. And this law in place in Georgia, this citizen's arrest law, is really the key to the case, as you said, Ben, because it's all about what the McMichaels and Mr. Bryden, so there's 3 defendants and there's slightly different defenses for each, but just in general, it depends on what they knew at the time. So obviously it's a better sell to a jury if a crime was committed, right? That's what the defense would hope for. And they made some points in the case where they said that the police investigation was not thorough, that certain areas were not canvassed, so perhaps something could have been dropped along the way. They're putting doubt in the jury's head. But even if a crime wasn't committed, if there was a reasonable suspicion to think that a crime was based on the information that they knew at the time, then they can have the benefit of the citizen's arrest law in addition to the self-defense statute, which, again, they have to get over that initial aggressor, which is where the citizen's arrest law comes in. So you are right on point. It's a very, very similar case in that sense. And it really does hinge on whether or not they were justified in this pursuit. And you know what? Based on some of the evidence that just came out, just the story has been turned on its head, because now we have insight without their testimony, on video, about what they knew prior to February 23rd. Now, that's absolutely critical, because that's what matters. There's a lot of red herrings in this case, but focusing in on the real issue, what did they know at the time? And that's the key.
So, Misty, final question for you. Obviously, one of the issues in the media coverage has been the race of the jury in the Arbory case, and it really is the McMichael case, because Arbury was the person who was shot. McMichael's the defendant. But in the McMichael case, the race of the jury is apparently 1 black person and 11 people who are not black. The media have made much of this fact, the suggestion being that if he's convicted, then justice has been done. But if they are not convicted, the McMichaels, then this is because of white racism. How did the constituency of the jury play in terms of race? There have been a lot of accusations that black jurors were being struck specifically because of their race. Is there any evidence to back that?
So the judge actually, the prosecution did what's called a baton challenge, where you say, hey, you can't strike jurors on the basis of race alone. That's a Supreme Court case that held that point. What the defense has to do in response, or the party being challenged has to do in response, is to lay down a legitimate, non-discriminatory reason for excluding certain jurors. And in this case, they were able to do so. There were many jurors who made statements about having preconceived notions about the case, already have drawn conclusions about the case, the type of stuff that's normal to exclude jurors for. So look, that was challenged. And the defense was able to justify each and every person that had been dismissed. So look, this is a common practice in criminal defense law. The challenges come up all the time. And so long as you hit that legal standard of legitimate non-discriminatory reason, you've satisfied your burden as the party that's being challenged in the case. So look, the judge made a comment that I thought was a little inappropriate, and I really like this judge actually, but he said it looks like there may have been discrimination. I don't think that was right, because under the law, the court only has so much discretion. And if you satisfy that burden, legitimate non-discriminatory reason, then the trial goes on. And there is no issue from a legal perspective.
Well, that is Misty Marris. She's a trial attorney based in New York City. You can check out her new podcast called The Legal Brief. It's on a platform called Call In, and she covers all of these criminal justice stories for HLN. Misty, really appreciate the time and the insight.
Thank you, Ben. Always happy to be on.
We're in a battle for the culture and for our values. Like and subscribe to help keep our videos on the front line of the fight and top of your feed.